Good morning, friends. My today topic is on Section 50 of the Ndps Act. In this judgment, which I am going to read out, is how much mandatory the provision of the Section 50 are that has been explained, and if that has not been followed, then the sure acquittal of the accused is there. So I am going through one of the judgment of the Punjab and Haryana High Court, that is in the High Court of Punjab and Haryana at Chandigarh, CRAS 4011 SP 2017. This judgment was reserved on 29th of April 2023 and is decided on 11th May 2023. In this case, Harjit Singh is the petitioner and State of Duty Chandigarh is respondent. And Honorable Mr. Justice Jesh Bhardwaj has now decided this case. The present appeal has been filed by the appellant against the order of conviction and sentence dated 1st June 2015, passed by learned judge, Special Court Chandigarh, whereby appellant had been convicted for the offence under Section 21 of the Ndps Act and sentenced to undergo RI for 28 days. Coming to the brief facts of the case, that are SI Mohan Singh along with Head Constable Kulwant Singh, Constable Sharndeep and Constable Ajay was on patrolling duty on 12th February 2014. A Naka was laid at the turn of Ready Market, Sector 41, Chandigarh, for checking the suspicious persons due to the increasing theft and snatching incidents taking place in the city. At about 6 p.m., they stopped a person coming from the side of Sector 41-42, Chandigarh. On seeing the police party, he got perplexed and started moving back. On suspicion, he was apprehended. He took out a polythene from the right pocket of his pant and tried to throw the same. However, SI Mohan Singh caught hold his hand and prevented him from throwing the polythene. On checking the same, it was found containing heroin. On the asking of SI Mohan Singh, he disclosed his name as Harjit Singh. He failed to produce any license for carrying the contraband recovered. On weighing, the same was found to be 10 grams. Two samples of 2 grams each were taken out of the polythene and were sent to CFSL, and remaining 6 grams was kept in the same polythene. The same was taken into possession Wide Recovery Memo XPV. The accused was found to have committed an offence under Section 21 of the Ndps Act. The Ruka XPC, Exhibit PC, was sent to the police station concerned, on the basis of which FIR XPD, Exhibit PD, was registered. On the registration of same, investigation commenced. Appellant was arrested on the spot. On conclusion of the investigation, Challan was presented and charges were framed. The prosecution examined SI Mohan Singh, IO as PW1, HC Kulwant Singh, the recovery witnesses as PW2, SI Jashpal Singh, the second IO as PW3, Head Constable Vinod Kumar, who deposited the sample with CFSL as PW4. SI Surendra Gautam, with whom the case property was deposited as PW5, SC Jashpal, who prepared the site plan as PW6, and Constable Praveen, who produced the case property before the court, and thereafter the deposited the same in Malkhana as PW7. Besides these witnesses, documentary evidence was also produced after conclusion of prosecution evidence. Statement of the appellant was recorded under section 313 CRPC, wherein he pleaded innocence and false implication. However, he led no evidence in defense. Thereafter, learned trial court heard the arguments of both the sides, and on conclusion of the proceedings, learned trial court found prosecution having proved the charges framed against the appellant, and thus he was convicted and sentenced as stated above under section 21 of the Ndps Act. Learned counsel for the appellant has vehemently contended that the appellant had been falsely implicated in this case. He submits that, as per case of the prosecution, recovery of the alleged contraband was effected from the appellant by SI Mohan Singh along with his team on 12th February 2014 at about 6 p.m. at the Naka laid down on the turn of Ready Market Sector 41, Chandigarh. He submits that evidently the recovery was effected from the appellant at a public place, but investigating agency did not join any independent witness. He submits that from the evidence produced on record, it is apparent that the investigating agency did not even try to associate any independent witness. It is submitted that SI Mohan Singh PW1 had deposed that the appellant tried to throw the polythene packet by taking out from his pocket, but he prevented him from throwing the same, and the recovery was effected on suspicion from his hand. He submits that once the recovery of contraband is effected from the hand of the appellant, the same amounts to recovery made from the search of the body of the appellant, and hence the statutory provision of section 50 of Ndps Act, which are mandatory in nature, were bound to be complied with. However, from the evidence produced on record, it is evident that the investigative agency had simply effected the recovery from the appellant without giving any offer under section 50 of the Ndps Act to the appellant. He submits that compliance of section 50 of the Ndps Act is mandatory in nature, especially when the recovery of contraband is effected from the search of the body of the accused. Counsel submits that in the present case, SI Mohan Singh had made the recovery of the alleged contraband from the hand of the appellant, but as he failed to give any offer under section 50 of the Ndps Act to the appellant, the conviction and sentence awarded by the Land Trial Court are unsustainable in the eyes of law. It is further submitted that from the oral and documentary evidence produced by the prosecutors, it is apparent that the recovery was effected from a public place, and the investigating officer did not join any independent witness, which further creates a serious doubt in the case of prosecution quashed on the appellant. He submits that the recovery of the contraband was effected on 12th February 2014, and as submitted by Head Constable Vinod Kumar, PW4, he deposited the samples with the CFSL on 13 February 2014. It is evident that the sample has been deposited after delay of 1 day. He submits that the recovery was effected in Chandigarh and CFSL was situated in Chandigarh itself. Thus, there is no explanation regarding depositing the sample on the next day, when the recovery was effected on 12th February 2014. Counsel has relied upon the judicial precedents in case of Jashpal Singh Urf Palla versus State of Punjab, criminal appeal number S1888 SV 2016, decided on 9th March 2017, and Sanjeev and another versus State of Himachal 2020 Live Law SC 267. It is submitted that in view of the above facts and circumstances of the case, prosecution has miserably failed to prove its case beyond reasonable doubt, and thus the conclusion arrived at by the learned trial court in convicting the appellant while impugned judgment is totally perverse, being against the evidence on record and law settled, and deserved to be set aside by acquitting the accused from the charges framed against him. On the other hand, Land State Council has vehemently opposed the submission made by the counsel for appellant. He has submitted that the appellant was apprehended by the investigating agency while they were holding a naka at the turn of Ready Market, Sector 41, Chandigarh. He submits that on seeing the police party, the appellant tried to escape from the spot. He was apprehended on suspicion, and as he made an attempt to throw away the polythene being carried in his pocket, SI Mohan Singh prevented him from throwing the same, and on checking the same, it was found containing 10 grams of heroin. It is submitted that it was a chance recovery factored from the appellant. He further submits that the recovery was effected from the polythene being carried by the appellant, and that Section 50 of the Ndps Act would not be attracted in this case. He submits that the prosecution has produced overwhelming evidence by producing the witnesses PW1 to PW7 beside the documentary evidence. It is further submitted that the material contradiction as alleged by counsel for the appellant are minor in nature and are not sufficient and to discredit the case of prosecution. And that is the view taken by the learned trial court in convicting the and sentencing the appellant did not suffer from any infirmity, and hence the present appeal deserved to be dismissed. I have heard learned counsel for the parties at length and have gone through the record carefully. As is evident from the facts, case of the prosecution is that a naka was laid by the police party at the turn of Ready Market, Sector 41, Chandigarh, and the appellant was seen coming from the side of Sector 41, 42, Chandigarh. On seeing the police party, he tried to escape from the spot, but he was apprehended. He also tried to throw the polythene being carried by him, but was prevented by SI Mohan Singh from throwing the same. On checking of polythene, recovery of 10 grams of heroin was effected. Though learned counsel for the appellant has argued regarding non-joining of the independent witness, and main thrust of his argument is regarding the compliance of Section 50 of the Ndps Act, which is mandatory in nature. It is evident from the case of the prosecution that recovery of light contraband was effected from the appellant from the polythene which he tried to throw after seeing the police party. Evidently, recovery was effected in a public place. There is nothing on record to show that the police party made any effort to join any independent witness at the time of search of the appellant. Besides this, the light contraband had been recovered from the appellant when he tried to throw away the polythene being carried by him in his pocket. Thus, the contraband was in the hand of the appellant when it was recovered by SI Mohan Singh, PW1. The police party did not give any offer under Section 50 of the Ndps Act to the appellant. The provision of Section 50 of the NDPC are as under conditions under which search of persons should be conducted. When any officer duly authorized under Section 42 is about to search any person under the provision of Section 41, Section 42, or Section 43, he shall, if such person so requires, take such person without unnecessary delay to the nearest gazetted officer of any of the departments mentioned in Section 42 or to the nearest magistrate. If such a requisition is made, the officer may detain the person until he can bring him before the gazetted officer or the magistrate referred to in subsection 1. The gazetted officer or the magistrate before whom any such person is brought shall, if he sees no reasonable ground for search, forthwith discharge the person, but otherwise shall direct that search be made. No female shall be searched by anyone excepting a female. When an officer duly authorized under Section 42 has reason to believe that It is not possible to take the person to be searched to the nearest gazetted officer or magistrate without the possibility of person to be searched parting with the possession of any narcotic drug or psychotropic substance or controlled substance or article or document. He may, instead of taking such person to the nearest gazetted officer or magistrate, proceed to search the person as provided in section 100 of the CRPC 72. After a search is conducted under subsection 5, the officer shall record the reason for such belief which necessitated such search and within 22 hours sent a copy thereof to his immediate officer. Within 72 hours send a copy thereof to his immediate officer, official superior. Honorable Supreme Court has settled the law by holding that in case of search of the body of the accused, compliance of section 50 of the Ndps Act is imperative in nature. Reliance in this regard can be placed upon the judicial precedents in case of Sanjeev versus State of Himachal Pradesh 2022 to RCR Criminal 341. State of Rajasthan versus Permanent 2014 3 SCR 522. Honorable Constitutional Bench of Supreme Court Vijay Singh Chanduba Jadeja versus State of Gujarat 2011 1 SCC 609. So for this purpose, it would be necessary to recapitulate the conclusion arrived at by Constitutional Bench in State of Punjab versus Baldev Singh 1993 3 RCR Criminal 533. We are concerned with the following conclusion that when an empowered officer or a duly authorized officer acting on prior information is about to search a person, it is imperative for him to inform the person concerned of his right under subsection 1 of section 50 of being taken to the nearest gazetted officer or the nearest magistrate for making the search. However, such information may not necessarily be in writing. That failure to inform the person concerned about the existence of his right to be searched before a gazetted officer or a magistrate would cause prejudice to an accused. That a search made by an empowered officer on prior information without informing the person of his right that if he so requires, he shall be taken before a gazetted officer or a magistrate for search, and in case he so opts, failure to conduct his search before a gazetted officer or a magistrate may not vitiate the trial, but would render the recovery of illicit article suspect and vitiate the conviction and sentence of the accused, where the conviction has been recorded only on the basis of possession of illicit article recovered from his possession during a search conducted in violation of provision of section 50 of the Act. Whether or not the safeguard provided in section 50 has been duly observed would have to be determined by the court on the basis of evidence led at the trial. Finding on that issue one way or other would be relevant for recording an order of conviction or acquittal, without giving an opportunity to the prosecution to establish at the trial that the provision of section 50 and particularly the safeguards provided therein were duly complied with, it would not be permissible to cut short a criminal trial. That in the context in which the prosecution has been protection has been incorporated in section 50 for the benefit of the person intended to be searched, we do not express any opinion whether the provision of section 50 are mandatory or directory, but hold that failure to inform the person concerned of his right as emanating from subsection 1 of the section 50 may render the recovery of contraband suspect and the conviction and sentence of the accused bad and unsustainable in law. That the illicit article seized from the person of an accused during search conducted in violation of safeguards provided in Section 50 of the Act cannot be used as evidence of proof of unlawful possession of the contraband on the accused, though any other material recovered during that search may be relied upon by the prosecution in other proceedings against the accused, notwithstanding the recovery of that material during an illegal search. It is not the case of the prosecution that the polythene from which the police party recovered the contraband was already thrown away by the appellant, but it was in the hand of appellant. Thus, in the opinion of this court, and in the light of law laid down, compliance of Section 50 of the Ndps Act is imperative in nature, which had not been made the present case. The contraband recovered from the appellant was found to be 10 grams herein which is non-commercial quantity. There is nothing on record to show that appellant had any criminal antecedents as he had never been involved in any other case of similar nature. As already discussed above, this police party did not join any independent witness in this case. There is no going saying that NDPS Act is special act and has the provision for the stringent punishment. Hence, the standard of investigation is also required to be meeting all those parameters which rule out the false implication of an innocent citizen. However, in the case in hand, the prosecution has failed to rule out the false implication of the appellant. Thus, in view of the finding recorded above, this court has no doubt in its mind to hold that prosecution has failed to prove its case beyond reasonable doubt as the compliance of provision of Section 50 of the NDPS Act has not been made in this case. Urgently, the present appeal is allowed, the impugned order convicting and sentencing the appellant is set aside, and appellant is acquitted of the charges framed against him. So, the importance of Section 50 has been stressed by the Honorable Court so that no innocent be prosecuted and convicted. That's all. Thank you for watching. God bless.